This is Bloomberg Law with June Grasso from Bloomberg Radio.
The Supreme Court struck down President Donald Trump's sweeping global tariffs, undercutting his signature economic policy. In a 6-3 vote that crossed ideological lines, the justices handed Trump his most significant legal defeat since returning to the White House. The majority, including 2 Trump appointees, found that the president exceeded his authority by invoking a federal emergency powers law to impose his global tariffs. Trump lashed out at the decision and the justices who ruled against him.
The Supreme Court's ruling on tariffs is deeply disappointing, and I'm ashamed of certain members of the court, absolutely ashamed, for not having the courage to do what's right for our country. I'd like to thank and congratulate Justices Thomas, Alito, and Kavanaugh for their strength and wisdom and love of our country.
Of course, the 3 justices congratulated by Trump dissented from the opinion. Joining me is international trade attorney Dave Townsend, a partner at Dorsey Whitney. Dave, Chief Justice John Roberts wrote the majority opinion, and it was basically a textual analysis, finding that the text of IEEPA, the International Emergency Economic Powers Act, didn't authorize the president to impose tariffs. He wrote, "When Congress grants the power to impose tariffs, it does so clearly and with careful constraints."
The Constitution gives Congress the authority to impose taxes and also to regulate commerce with foreign nations. And that constitutional context, I think, was important. Basically all of the opinions, creating a posture that we would expect Congress to speak clearly if they intended to give that power away via IEEPA. And the part that you read, June, relates to, primarily a statutory interpretive question of, would Congress have meant IEEPA to give tariff authority to the executive branch? And the court answered no, that was not intended by Congress.
The Chief Justice came up with what's been called the major questions doctrine about 4 years ago. It basically says that Congress has to explicitly authorize policies that have a major nationwide impact. How did that doctrine play in this decision?
Roberts uses the major questions doctrine in part to resolve the statutory question before the court, holding IEEPA doesn't authorize tariffs. There is a lengthy concurring opinion by Justice Gorsuch in which he goes into depth of the major questions doctrine, and then also opinions from Justice Barrett talking about some of her differences with how Justice Gorsuch applies the major questions doctrine, and then the so-called liberal justices who say we think traditional statutory interpretation questions aside from the major questions doctrine allows us to resolve the case. But all of the justices discuss that issue. What is the major questions doctrine? When is it appropriate to apply? And does it apply to the case here?
How important is it that 2 Trump appointees, Justices Amy Coney Barrett and Neil Gorsuch, and particularly Justice Gorsuch, who's among the most conservative members of the court and is usually a reliable vote for Trump, how important is it that they sided with the majority here?
Justice Roberts, has long spoken about the legitimacy of the court. I would answer that question, June, just by saying I think Roberts is very pleased to have justices who are appointed by President Trump join him in this landmark opinion.
Where did the conservatives who dissented find authority for the president to issue tariffs?
So the dissents would have said that the IEEPA text itself is intended to encompass the authority to issue tariffs and thus upheld President Trump's emergency tariffs. And the language of IEEPA is broad. It uses a lot of authorizing language for the executive to take various actions, including to regulate importation, which is the key phrase that was really at issue here. And, I think some of what the dissent is saying, at least in part, is reasoning that, the president has blocked imports, prohibited commerce under U.S. economic sanctions for decades, citing IEEPA. And if that authority allows blocking and prohibiting, why wouldn't the language to regulate importation permit a more calibrated response, which is tariffs? as President Trump chose to use here.
President Trump, who was extremely disappointed by the decision, has already announced workarounds for the tariffs.
Today I will sign an order to impose a 10% global tariff under Section 122 over and above our normal tariffs already being charged.
So then will this decision not really make that much difference to the administration and its trade policy?
I think as a matter of trade policy, that's probably right. I think that they will and have prepared for this long enough that they see an avenue for them to impose tariffs in a way that doesn't really fundamentally change the map, so to speak, with respect to U.S. trade policy.
Why do you think the court didn't address the extent to which importers are entitled to refunds of the tariffs?
That's a tough question. And, it's a 170-page opinion. The dissent points out that the majority says nothing about refunds. And, if you go through the opinion, it's all about the statutory interpretation, the merits question, not the remedy question. At the U.S. Court of Appeals for the Federal Circuit, it had remanded this case back to the Court of International Trade, which is at the district court level for this particular case, to examine whether a nationwide remedy was appropriate. And it said that intervening authority of the Supreme Court required the Court of International Trade to look at that issue anew. That intervening authority is Trump v. Casa, which discussed the appropriateness of a federal judge issuing a nationwide remedy. So I think the net effect of the opinion is they affirmed the Federal Circuit opinion. The Federal Circuit opinion had told the Court of International Trade to look at that issue. And that's where we go now with respect to refunds.
And so it'll be litigated at the Court of International Trade. Would refunding be as messy as Justice Kavanaugh says?
The messy language comes from what Justice Barrett said during oral argument. And Justice Barrett here sides with the majority to strike down the tariffs. And so Justice Kavanaugh is saying, well, how do we proceed here? It's going to be a mess. I think that it's really unclear what happens next on the refund issue. From my perspective, as a trade attorney, I advise importers about tariffs all the time, and it's largely automated in the sense that it's possible for U.S. Customs to look at each individual import on an entry-by-entry basis and see how much in IEEPA tariffs have been paid. So I'm not convinced it needs to be messy, but it depends on a lot of things now. It depends on how the administration reacts, depends on how the Court of International Trade, reviews that issue in the first instance and then potential appeals from there.
I want to talk about the significance of this decision outside of tariffs. Do you think we can read more into this decision? For example, is this the start of the Supreme Court restraining Trump and his agenda? Could these principles be used in other circumstances, or are they limited to this specific statute?
It's significant and broad in the sense that these IEEPA tariffs have been imposed under a variety of executive orders for a variety of purposes, right? You had the global reciprocal tariffs, you had the fentanyl-related tariffs, you had the Iran-related tariffs imposed with respect to imports from India, and presumably this opinion says all of those tariffs are illegal. So it's very broad. It is landmark. It's an enormous decision covering, importers who've paid between $130 and $150 billion. Now, what it says outside the scope of IEEPA, I'm not sure. That would get very speculative, and it would be difficult, given what the Supreme Court said, that it's ultimately a statutory interpretive question that they resolved here, to really say that this says anything about the validity of tariffs outside of IEEPA.
And Dave, as a trade lawyer, what are you going to be looking for after this decision?
I think that one issue will be interesting to watch now is the reaction not just from importers and not just from the administration, but also international trading partners. We have all these trade agreements that are based on, and the underlying assumption is that IEEPA tariffs apply and that a new agreement is reached between the White House, the USTR, and these foreign countries. Now that the IEEPA tariffs have been held unlawful, it'll be interesting to see what happens next. There might not be a significant change, and I think the administration will say nothing has changed with respect to those agreements. And it'll be interesting to see if foreign countries continue basically to say, yeah, we continue to view those agreements as valid. nothing's changed. We're going to keep going as though those agreements are the bargain under which the U.S. and those trading partners will do business.
And on the Supreme Court side of things, it'll be interesting to see which of the justices show up for President Trump's State of the Union address on Tuesday, considering that he called the justices in the majority unpatriotic and disloyal to the Constitution. Thanks for your insights, Dave. That's Dave Townsend, a partner at Dorsey Whitney. Coming up next on the Bloomberg Law Show, a coalition of conservation and historical organizations are suing the Trump administration over its efforts to erase history and science at our national parks.
You cannot erase our history. Yes, it is flawed. Yes, it is imperfect.
Philadelphia's mayor praised a federal judge ordering the Trump administration to restore displays discussing slavery at a site in the city where George Washington lived as president. Last month, National Park Service workers used hand tools to pry off 34 panels about 9 people enslaved by Washington. It's part of the Trump administration's removal of information related to racism and slavery, sexism and LGBTQ rights, indigenous communities, and climate change from the nation's museums, parks, and landmarks. The National Parks Conservation Association and 5 other nonprofits are suing the administration to stop what they call a sustained campaign to erase history and undermine science from national sites. Joining me is Alan Spears, Senior Director of Cultural Resources for the National Parks Conservation Association. Alan, will you give us the timeline of the Trump administration's effort to remove information from the national parks?
So this process got started shortly after President Trump was reelected and re-entered the White House. And in March of 2025, he issued an executive order to restore truth and sanity to American history. And that was followed 2 months later by a secretarial order issued by Secretary Doug Burgum, Secretary of the Interior, that essentially operationalized the president's executive order for all of the agencies in the Interior Department, including the National Park Service. And so had QR codes placed in national parks so that visitors could tattle on National Park Service employees if they found that the interpretation at a site was a little bit too left-leaning or, in their view, denigrated Americans. And that was followed by an order for National Park Service staff to assess everything in their interpretive inventories, whether it was related to race or gender or climate science, anything that might run afoul of the secretarial order or the president's executive order. They were required to put that on a list and submit that list to the Interior Department. And those lists were filled out and then submitted over the course of the end of the summer of 2025. And then in the fall of 2025, we kind of went into a hiatus where we heard some things were being removed, other things weren't being touched. People were considering what was on the list. And then we got started with a bang in January when we saw the National Park Service take down the displays at the President's House at Independence National Historical Park in Philadelphia. And we have also seen other signs that were taken down, a sign on sea level rise at Fort Sumter, signs about climate change at Acadia National Park, a couple of videos at Lowell National Historical Park in Massachusetts that talked about the pollution of the industrial era and the challenging work environment for some of those young women who were working in the mills in Lowell during the Industrial Revolution in this country. And we've seen signs about native history and culture that have been removed from the Grand Canyon. And we're hearing stories, anecdotal evidence of the fact that there is a large list of sites out there, many of whom have commemorative or interpretive materials that are related to the African American experience, either slavery or civil rights, that are on somebody's list. And we may yet see additional operations coming from the Trump administration, from the Secretary of the Interior, from the National Park Service to remove or erase or censor or sanitize elements of our shared national narrative as it is interpreted by our National Park Service.
Is it any reference to slavery, LGBTQ rights, climate change, etc.? How are they deciding what's objectionable?
Oh, that's a great question. There is no transparency in this process. And so as an advocacy organization, the National Parks Conservation Association is engaged in a game of whack-a-mole where we've got something happening at Independence Park in 1 week, and then something happening at the Medgar and Murray Evers home potentially the next week. And so it goes. So there is no transparency. There doesn't seem to be any process. And sometimes we've got directives coming down from above, get rid of this, or we've got people in national parks who themselves are trying not to get in any kind of trouble, thinking, all right, maybe we ought to take that down, or that program that we were going to have on enslaved people in the Underground Railroad, maybe let's postpone that. But the challenge right now is we don't have a clear sense of exactly what's happening, so it makes it really difficult to react to that. What I can tell you is we know now that the word transgender has been scrubbed from National Park Service interpretation, and we know that it's been scrubbed from the interpretive arrays at the Stonewall Inn in Lower Manhattan. That was the site of the LGBTQ uprising in the summer of 1969 that launched the modern LGBTQ civil rights and human rights era. And that protest, that uprising, was led by transgender activists. And so they have been excised from the history of an event that they started and helped to organize and lead. And we are seeing also at the president's house and other places, it seems as if there are some folks in the administration who believe that restoring truth and sanity actually means getting rid of any references to anything related to race or gender or sexual orientation, labor, class, women's rights, or climate science that makes some people feel uncomfortable. So the idea is you take those things out of the interpretive array and you can go and have a fine time at any national park that you want to visit, and you will never have to learn anything or think critically about any issue, because we are just going to look at the unfiltered, unalloyed progress of this country from start until the current time right now, when it's been nothing but progress, progress, progress. And I would just round out those comments by saying this is an amazing country. We have a broad and diverse history. It's complex. I think the complexities are the things that make it interesting. We have joined with allies to defeat fascism. We have brought inspiration, political, scientific, cultural, to all parts of the globe. We've cured dread disease. And there are times when we have failed to live up to the better angels of our nature. That's us too. And so when it comes to national parks and historic interpretation, we want the full story to be told in our national parks, because we can handle the truth, and we got to have that truth.
And what are you hoping to accomplish with your lawsuit?
The aim of our lawsuit is to just put a stop to history erasure and signage removal. Let's stop it. And then let's see if we can't, through other means, perhaps even legal means, reverse that trend and then repair what's been lost. So that's the purpose of the lawsuit. We want to stop any additional signage removal in the name of restoring truth and sanity to American history in our national parks.
I take it you're hoping for more rulings like that from federal judge Cynthia Roof, who ordered the Park Service to restore the panels on slavery. She found the federal government doesn't have the power it claims to dissemble and disassemble historical truths. And she said it echoes Big Brother's domain in George Orwell's 1984.
That's exactly correct. Yeah. At this point in time, we have an administration right now that has taken this restoration of truth and sanity issue too far. And I think the judge in the ruling for the preliminary injunction spelled it out that the actions being taken by this administration related to the Philadelphia case are capricious and arbitrary. We certainly feel like that's the case nationwide with some of the things that have been removed. You know, it takes the National Park Service months and sometimes years to develop interpretive arrays and signage that get placed in national parks. They consult with historians and museum collection specialists and ethnographers and archaeologists and community members and descendant communities and historians from outside the agency to get together and develop really good, accurate, inclusive interpretation that will benefit the public and enlighten the public and enhance public knowledge about our history. What's happening right now is it seems that somebody is in charge of an algorithm that anytime it finds anything in a brochure or on a National Park Service interpretive sign that mentions the word slavery or the initials LGBTQ, it gets yanked out or it gets flagged for removal. That's not a rigorous historical academic process. Again, we've got a very complex story. We benefit when we're able to learn about where we've come from and about the breadth and depth of the contributions that people from a variety of backgrounds have made to this country to make us the people that we are today.
So you describe this as a game of whack-a-mole. You don't know where, in what national park, some information is going to be taken down. So even if you get a judge's order, how will that be enforced?
Well, that's a good question. That is also something for the lawyers and the legal teams to figure out. And, once a ruling is made, we would hope that everybody would abide by the law and by the findings. And the idea is we have, at this point in time, a problem that goes well beyond signage. And I think that's the challenge that we've got right now and that we're trying to communicate to the public. So if, let's say, the installation about enslaved people that came with George Washington and served his family in Philadelphia when he was president, let's say those signs are removed and they stay down, we lose an opportunity at that site to have a conversation about the issue of slavery and its place in the founding era of this country. And let me tell you, George Washington, as our president, deserves a world of credit because he's the guy that helped to establish our democratic traditions. When he got to the end of his second presidential term, he was standing next to some people who were elbowing him and saying, General, you know people with muskets. We know people with muskets. We can keep you in this position for as long as you'd like to be the supreme leader of this nation. And Washington, to his credit, said, no. I believe in civilian leadership and peaceful transition. We're going to have an election. We're going to let the next person come in and take over the presidency. So our democratic traditions extend to George Washington and his ability to be that self-effacing. And he was also a guy who owned several enslaved Africans. And I think we need to be at a place where we can walk, chew gum, and think difficult thoughts all at the same time. And so what we hope through this lawsuit is to suggest to the administration and to the people in America that this is an important issue. We don't need to erase our history. We don't need to hide from our history. We benefit, all of us, by being able to think critically about things that happened in our past that still very much influence us to this day. So in that regard, the lawsuit starts with the notion of stopping history erasure and signage removal, but it goes well beyond that. It's a much more important and challenging issue that we're facing right now.
Alan, I'm curious about something. So websites have been scrubbed of information about slavery, sexism, climate change, etc. Is that erased information stored somewhere so you can restore it right away when you get a judge's order? Or do you have to go through some other kind of process to develop the information again?
It's a little bit like the novel Fahrenheit 451, where the people wander around in the woods and they've memorized all the poetry and the science and the literature, and they share those oral histories with young people so that at some point in time in the future they can come back and maybe republish all the books that have been burned. We're not quite at that stage at this point in time, but we do have an organization called Save Our Signs. And we do have people who have taken photographs of websites, screen captures of websites. So we do have a sense of before and after. And I think there will be the ability to rebuild and repair. But I would also tell you this. There were some reports or some people who suggested that the National Park Service at the president's home in Philadelphia were ripping down these displays and maybe even tossing them into garbage cans. That's not what happened. They were taken down carefully. They have been put in a place whereby, as they have been ordered by a judge at some point in time, we hope to see them restored to their rightful place at the president's home, display on enslaved people. And so we do have ways that we can recover this information, even if it has been sanitized or erased from a website. But the lawsuit that we have initiated is to make sure that we don't lose anything else.
It's so important to preserve our history. Thanks so much for joining me, Alan. That's Alan Spears of the National Parks Conservation Association. Coming up next, the legal fight over the EPA scrapping a major climate rule. I'm June Grasso, and this is Bloomberg.
Effective immediately, we're repealing the ridiculous endangerment finding and terminating all additional green emission standards imposed unnecessarily.
It took less than a week for lawsuits to be filed over the EPA's elimination of the bedrock scientific finding that greenhouse gases threaten public health.
Don't worry about it because it has nothing to do with public health. This was all a scam, a giant scam.
The so-called endangerment finding forms the basis for regulations to fight climate change, and its revocation could unwind current air and climate rules. So a coalition of conservation and public health groups and a group of youth plaintiffs are challenging the repeal, saying it violates federal law and legal precedent. And more lawsuits are sure to follow on an issue that's likely to reach the Supreme Court. My guest is an expert in environmental law, Pat Parenteau, a professor at the Vermont Law Graduate School. Pat, just how critical is this revocation of the endangerment finding?
It's huge and it's ugly, and people do not fully understand just how devastating this action is going to be, not just for climate, but for public health and safety generally.
And the endangerment finding came out of a landmark Supreme Court case in 2007.
Right. So it follows on the heels, of course, of Massachusetts versus EPA, which is still the law of the land, contrary to what Mr. Zeldin thinks. And in that decision, the Supreme Court not only held that greenhouse gas pollution is regulated under the Clean Air Act, the George W. Bush administration had taken the position it wasn't regulated, and they made many of the same arguments that Trump and Zeldin are making now. And the Supreme Court rejected those. It was a 5-4 decision, and frankly, the majority in the Massachusetts case is no longer on the court, so that's what gives Trump some hope here. And then secondly, the Supreme Court said, since you have the authority to regulate greenhouse gas pollution, if you make a finding that such pollution and the emissions that cause it endanger public health and welfare, you must regulate. You don't have any discretion not to regulate once you make a finding. And the Supreme Court made it clear that was a scientific finding. It wasn't policy. It wasn't even law necessarily. It was a scientific determination that this kind of pollution is endangering people's health and welfare. So the science is absolutely crystal clear, and the danger is absolutely clear. You can repeal the finding. You can't repeal the danger.
There are 2 lawsuits and counting, one by a group of youth plaintiffs and another by a coalition of health and environmental groups. Tell us about their claims that the EPA's actions are illegal.
Well, they're first of all saying that Massachusetts versus EPA is the law, and as I said, it states very clearly that EPA has the authority to regulate. So now Zeldin is coming along and saying, well, no, we've looked at it again through the lens that we use, and our conclusion is that the best reading of the Clean Air Act is not the reading that the Supreme Court issued in Mass versus EPA, but our reading, which is we don't have any authority to regulate greenhouse gases. They're using kind of an originalist argument here. They're trying to say that because the Clean Air Act of 1970 was focused on initially localized pollution, the smog that people were breathing and so forth. But it's not true that the Clean Air Act was limited geographically. We have multiple instances where the Clean Air Act has been used to tackle long-range pollution, not just acid rain, but ozone pollution, smog pollution, fine particulate pollution that floats across the United States, from upwind states to downwind states. So this notion that the Clean Air Act was never intended to regulate anything in your immediate area of the air you're breathing is simply flatly wrong. That's never been the law. No case has ever said that. The Supreme Court has never said that. Only Zeldin is saying that. So the first argument is there really is no legal basis whatsoever for repealing the endangerment finding. And, of course, they also repealed immediately what we call the tailpipe standards, the mobile source standards, cars and trucks and so forth. They are the largest source of this kind of pollution and a lot of other pollution as well. So the notion that this isn't a significant category, that's another requirement of the Clean Air Act. You have to make a finding that there's a danger from these pollutants, but then you have to look at the sources of the pollutants and say those sources contribute to the danger. But if this is the largest source of greenhouse gases and these other pollutants, they surely contribute to the danger. So there's no legal basis, no scientific basis, and there are lots of other arguments for why this finding is not based on the law.
Particularly in light of Massachusetts versus EPA, why do you think the EPA administrator, Lee Zeldin, took this route?
Zeldin is counting on the current composition of the court. As I said, the majority that was in place in Massachusetts versus EPA is no longer there. It's much more conservative. So you have to look at, can Zeldin get the court to take review of this issue and reverse Massachusetts versus EPA. So this requires basically a head count. Where do you get 5 votes on this court to overturn Mass versus EPA? You don't have the liberal wing of the court. You don't have Chief Justice Roberts, who wrote the dissent in Massachusetts, because he has stated publicly, even though I dissented, I think Mass versus EPA at this point is settled law. It's been on the books for 19 years, right? Lots of reliance on that decision, lots of regulatory actions based on that decision, lots of industry actions in response to that decision. So you're not going to get Chief Justice Roberts' vote. So where do you get the 5th vote? You've got the 3 or 4, perhaps, ultra-conservatives on the court. That would be Justice Thomas, Justice Alito, Justice Gorsuch, and probably Justice Kavanaugh, although even that's not sure. So where does the 5th vote come from? It almost has to be Justice Barrett. And my view is that she's not going to go along with overturning Mass versus EPA because of a doctrine that we call statutory stare decisis. So once the court has interpreted a statute, as opposed to, say, interpreting the Constitution, which can change over time, as we've seen, but when it comes to interpreting a statute, like the Clean Air Act, the doctrine that that kind of precedent should not be overruled, or at least lightly overruled, is very, very strong. And I think Justice Barrett has the kind of sort of institutional integrity on the Supreme Court to respect that. So I don't see how they get Justice Barrett's vote.
Pat, the Supreme Court has surprised us many, many times. So suppose they do get that 5th vote and Massachusetts versus EPA is overturned. Can that be undone by the next president and the next EPA?
That would have really devastating consequences because it would mean that a future president could not reinstate the endangerment finding. Once the court has determined there is no authority to regulate greenhouse gases unless Congress steps in, and that doesn't look very likely, that's the end of the ballgame. That's the end of federal regulation of climate polluting emissions. Devastating.
So then it seems like there's a danger in escalating this fight to the Supreme Court.
Oh, I think so. I mean, it's the old adage, be careful what you wish for. If Trump is successful in getting the court to agree with him, then what happens is the Clean Air Act no longer regulates these pollutants, but that means states like California are free to do so, and you can be sure they will. California has already adopted the most stringent tailpipe standards, fuel efficiency standards in the country, and 13 other states have gone along with California. That got overturned by Congress. That's another story. But the point is, once the Clean Air Act is no longer an obstacle to state regulation, it is no longer preempting California and other blue states from regulating these pollutants, not just from cars, but from lots of other, sources as well, power plants, oil refineries, etc. That creates a patchwork of regulation across the country. Chaos, because there'll be litigation over that as well. The one thing that industry hates is that kind of chaos, that kind of unpredictability. How do you make investment decisions in a regulatory environment like that? The one thing about federal regulation is once it's in place, that's the baseline. That's what everybody can plan against, and particularly for automakers. So that's number one. If Trump wins, industry loses. Number two is the oil companies also lose because the oil companies have been somewhat successful getting state and city and county lawsuits against them for climate damage. These are the so-called deception cases, public nuisance cases, more recently climate superfund cases, and so forth. And the oil companies are making the argument the Clean Air Act preempts all these lawsuits for damages. So if Trump wins the repeal of the endangerment finding on the basis that the Clean Air Act doesn't regulate these pollutants, their preemption argument goes out the window. So, there are two really bad consequences from upholding what Zeldin has done, neither of which benefits industry, doesn't benefit automakers, doesn't benefit utilities. It just creates chaos.
I'm wondering if there's a way for the plaintiffs here to slow walk these lawsuits so that they don't reach the Supreme Court during Trump's term?
That is the strategy, I think, of the environmental groups that have sued and the blue state attorneys general led by California and Massachusetts, which is sure to follow here shortly. I think that's their strategy. And slow walk, yes, there are some ways to do that. Number one, you can, argue for a really long-term briefing schedule. Lots of issues here. There were 570,000 comments on this proposed rule. The APA requires EPA to respond to those comments. There's no way EPA has done that in the time frame that they've been working on that. So, they're going to be vulnerable on any number of procedural issues. So all of that means the briefing is going to be incredibly detailed. The page limits are going out the window. They're going to double or triple the normal briefing that you're talking about, plus the administrative record. You can also be arguing that the record's not complete. Short of it is there are strategies and tactics that lawyers can legitimately use to stretch out the briefing, the argument, and so forth. Whether they can stretch it out for the full almost 3 years, that's an open question.
So we'll keep watch for the motion practice to begin. Thanks so much, Pat, as always. That's Professor Pat Parenteau of the Vermont Law and Graduate School. And that's it for this edition of the Bloomberg Law Show. Remember, you can always get the latest legal news on our Bloomberg Law podcast. You can find them on Apple Podcasts, Spotify, and at www.bloomberg.com/podcast/law. And remember to tune into the Bloomberg Law Show every weeknight at 10 p.m. Wall Street time. I'm June Grasso, and you're listening to Bloomberg.